Good afternoon. I am a member of the jury in the case of Jennifer versus AU Hospital. This case that we heard was in regards to Jennifer's private health information being released on a subpoena that was given to AU Hospital without Jennifer's consent or acknowledgement. Both sides of the case have presented strong evidence to rule in their favor. However, after carefully reviewing both sides of the case, I have decided to rule in favor of the plaintiff, Jennifer. AU Hospital was in fact at fault and should have never released Jennifer's personal health information. The plaintiff stated that she never received any notice of a subpoena or that her personal health information had been requested. Therefore, she never gave permission for any of this information to be released. The plaintiff trusted her healthcare organization and provider that whatever she said or wrote and medical history and information would stay private and fall under doctor-patient confidentiality. Confidentiality refers to the ethical and legal obligations to refrain from sharing information without their authorization. Jennifer did not give any authorization for her information to be released. I think it is extremely important to point out that only her information at AU Hospital was used during her divorce proceedings and that no other health information was received from elsewhere. This specific subpoena was not issued by a judge, therefore by a court clerk or attorney. I think it is important to note that therefore this was not a court order. The defendant, AU Hospital, stated that they were in line with the requirements for them to release the information in accordance with the notifications of the privacy rule. They stated that they mailed a letter to a previous known address. As a member of the jury, in my opinion, I believe that to reach the reasonable effort status that is outlined within the law, they should have used more than just a single letter to give her written notification. I also believe that AU Hospital should have used another method besides just mailing a single letter. This shows lack of effort in their notification process with such important information being released about Jennifer. As outlined in the law, the entity must have made a good faith attempt to give the patient written notice. This, in my opinion, did not happen. The defendant did claim that they called the plaintiff multiple times, which I find sufficient when meeting the verbal standards of trying to contact her. Jennifer was never given notification, and she was never given the chance to object to her information being released. The second stipulation of the notifications of the privacy rule state that they must seek a qualified protective order for the information from the court. Thus, the hospital must show that they are releasing this information and it will only be used for the specific reason of the subpoena and only that. The party requesting the information must also present a written statement and documentation accompanying the subpoena. I see no effort on AU's part to protect Jennifer's information in the legal proceedings of the subpoena and in its release in general. It is AU's job to protect and fight for the right to privacy of one of their patients. Their patients are entrusting them with personal information and entrusting that they will protect that information to their full potential. Once again, this did not happen in Jennifer's case. AU Hospital should have done a better job verifying the following conditions were met before the release of her medical information. The first one being that the patient was authorized the disclosure of the requested health information and that the type of information that was sought after in the subpoena. This is especially important when the medical records contain sensitive information. When dealing with sensitive information, this can include HIV and AIDS testing, certain medical records, especially mental health records, alcohol and drug treatment records, and genetic test records. Jennifer's information at AU Hospital did in fact have mental health issue records that would be considered sensitive information. AU Hospital could have renegotiated the information that was sought after in the subpoena as to make sure that this did not include sensitive information, but still abide by the subpoena without being punished. With all this information and supportive details, I stand by my decision to support the plaintiff that AU Hospital should have never released her information. Thank you very much for your time.